Hello, friends, and welcome back to another episode of the Liberty Weekly podcast. I'm your host, as always, Patrick McFarlane, and this is episode 80, which may be found at libertyweekly.net/80 or on the Libertarian Institute in the podcast section. And today I want to be talking about a very important an unimportant Supreme Court ruling decision in an important case. And this is the Masterpiece Cakeshop Ltd v. Colorado Civil Rights Commission case. And I feel today I've been feeling like uniquely qualified to answer this question, although it's been frustrating because I've been seeing a lot of liberty-minded people getting this decision wrong. And I've been seeing a lot of people kind of making fun of mainstream news outlets because a lot of mainstream stories have been saying in a narrow ruling issued 7-2, the Supreme Court ruled in favor of Masterpiece Cakeshop. And they've been saying, oh, this isn't a narrow ruling. How could it be narrow? The vote was 7-2. Well, it's narrow in the sense that the Supreme Court really didn't decide anything. It issued its decision, and the bounds of that decision was very narrow in scope. And that's actually very frustrating for the liberty-minded. Because, and as we'll see and we get into, the Supreme Court really took the long way around the issue. And they really didn't decide much of anything. This case was about compelled speech. It was not about discrimination laws, and it was not even about the free exercise clause, which was kind of how the Supreme Court ruled. And that isn't very satisfying this isn't a win for liberty. I've been seeing a lot of people that have been posting around saying this is a big win for liberty, and they've been saying that, property rights are sovereign, and this should have been decided based on, property rights or economic commercial speech or something like that. But it's a little more complicated than that, and I wanted to get into that decision here. So I'm aiming for this show to be around 30 minutes long, so I don't want it to be too long. I want it to be watchable, but I also want it to clearly display the issues at play in this case. So this is your one-stop shop, the SCOTUS blog. This is where I go kind of to understand what the cases are about that are coming up with the Supreme Court. And here we have the decision. This is the main page for the decision in the SCOTUS blog, as you can see on screen here. So this is the docket number, the court that was below, the Colorado, let's see. This was one of the below decisions. And the court issued this decision today. And the holding was very narrow. The Colorado Civil Rights Commission's actions in assessing a cake shop owner's reasons for declining to make a cake for a same-sex couple's wedding celebration violated the free exercise clause. Now, what this holding should say is that the Colorado Civil Rights Commission's actions in assessing a cake shop owner's reasons for declining to make a cake for a same-sex couple's wedding celebration was compelled speech and therefore is unconstitutional. But we have this narrow holding right here. Now, the judgment was reversed from the lower court. The lower court ruled in favor of the Colorado Civil Rights Commission, and that judgment was reversed by the Supreme Court in a 7-2 opinion. So that was 7 justices voted or ruled in favor of the Masterpiece Cakeshop, and 2 ruled in favor of the Colorado Civil Rights Commission. And so this is the main page on SCOTUS blog. Here are all the filings, and you can see a whole bunch of amicus briefs that were filed. I believe there's one from the Cato Institute too. Yep, here it is right here. We're not going to get into this, but there are a lot of very interested people, and this just goes to show the importance of this case, the potential importance of this case, and why this ruling is very unsatisfactory and not satisfying. So here's all the amicus briefs. You can get into that. And look at that. I mean, so many interested parties here. We're going to be taking a look at this, the reply of the petitioner's Masterpiece Cakeshop. And interestingly enough, one of the co-counsels for Masterpiece Cakeshop, his name is Jordan Lawrence, and I was vice president of the Federalist Society at my law school in my 2 and 3L years, and we had Jordan Lawrence come and speak last semester about this masterpiece Cakeshop as he was working on it. And he didn't do the oral arguments, but he worked on this right here. And this is clearly a compelled speech case. We got into it. This guy was super duper smart, and so I had that unique chance to sit in and hear what he had to say about the case. And he thought it was, if I remember correctly, he thought that it was kind of a slam dunk compelled speech case, classic. And so here we get into the opinion analysis by Amy Howe, and I'll include links to these in the show notes page. But she says here, opinion analysis, court rules narrowly for Baker in same-sex wedding case. And this is such a safe decision, I feel, for the Supreme Court. So she says the Supreme Court ruled today in favor of Jack Phillips, a Colorado baker who refused to make a custom cake for a same-sex couple because he believed that doing so would violate his religious beliefs, sincerely held. This was one of the most anticipated decisions of the term, and it was relatively narrow. Although Phillips prevailed today, the opinion by Justice Anthony Kennedy rested largely on the majority's conclusion that the Colorado administrative agency that ruled against Phillips treated him unfairly by being too hostile to his sincere religious beliefs. Now, this is disappointing for me, and I'll tell you why in a second. The opinions seem to leave open the possibility that, in a future case, a service provider's sincere religious beliefs might have to yield to the state's interest in protecting the rights of same-sex couples, and the majority did not rule at all on one of the central arguments in the case. This is the one presented by Jordan Lawrence. Whether or not compelling Phillips to bake a cake for a same-sex couple would violate his right to freedom of speech. This is compelled speech. So the state getting involved is compelling Phillips to participate in a message that he does not agree with. And immediately this harkens to the Live Free or Die case. And I can't remember what the name was just off the top of my head, but it included someone in the state of New Hampshire, shout out to the Free State Project, but someone in the state of New Hampshire who didn't want the license plate that said Live Free or Die. And they sued because they argued that this would be compelling the speech of whoever has the license plate. They would be forced to propagate a message that they disagreed with, and that's impermissible under the First Amendment. That receives strict scrutiny, the highest level of protection. We do not want to compel speech. That requires a substantial or a large governmental interest in order to overcome that protection. And this is the same case. This is very similar to that case. And so that's why I thought this was a slam dunk. So did Jordan Lawrence. It sounded like to me that was compelled speech. So the dispute, we know the facts generally. This case has been made famous by Gary Johnson by saying that he would force a Jew to bake a Nazi cake in the debates, most famously. But so the dispute that led to today's ruling began in 2012 when same-sex marriage wasn't even legal at this time. When Charlie Craig and David Mullins went to Masterpiece Cakeshop, a bakery outside Denver, to order a cake to celebrate their upcoming wedding. But Jack Phillips, the owner of the bakery and a devout Christian, refused the couple's request because he is not willing to design custom cakes that conflict with his religious beliefs. A Colorado civil rights agency ruled that Phillips had violated the state's anti-discrimination laws and told him that if he wanted to make cakes for opposite-sex weddings, he would have to do the same for same-sex weddings. Okay. After a Colorado court upheld that ruling, Phillips went to the U.S. Supreme Court last year. So almost 6 months to the day after the oral argument, the justices handed today Phillips a victory, even if not necessarily the ruling that he and his supporters had hoped for. Kennedy, the author of some of the court's most important gay rights rulings, began by explaining that the case involved a conflict between two important principles. On the one hand, society, yada, yada, yada. Okay, well, I won't get into that, but the crux of this here that I want to focus on as I get into the actual decision that was handed down, this case turned on the free exercise clause. And I don't think it should have turned on the free exercise clause. As she said, it was very disappointing I think this is a very political move by the Supreme Court because they don't want to set too much precedent. I think maybe they realize that the country is so divided right now that they really just don't want to touch this issue. This is akin to like taking the back road. So you're on the interstate and you're going through a city. This is akin to getting off on the exit before the city limits, driving the back roads around the city, and then getting back on the interstate, when you could have just taken the interstate all the way through straight go. Instead you go on the back roads and you go take the longest way around, and in doing so you stay completely safe. So basically this is disappointing because the Supreme Court they basically ruled. And okay, here, let's just get into the opinion right here. This is the very last paragraph, saying that they basically turned their decision on this. The Commission's hostility was inconsistent with the First Amendment's guarantee that our laws be applied in a manner that is neutral towards religion. This is textbook First Amendment. The government has to be neutral. It can neither discriminate against religion or endorse religion. It has to be neutral. Phillips was entitled to a neutral decision-maker who would give full and fair consideration to his religious objection as he sought to assert it in all the circumstances in which this case was presented, considered, and decided. So basically, the court is just saying that the Civil Rights Commission was so hostile towards Phillips. They were comparing him to like the Holocaust and Nazis and stuff, typical leftist garbage, social justice stuff. They said they were so hostile to him that they violated the free exercise clause. Well, there's a huge body of jurisprudence on the free exercise clause. This is not deciding anything fundamental here. This is just skirting around the issue of compelled speech. So I've already kind of busted into the decision. But I want to go back to the opinion analysis because this has really good little nuggets here. So here, Kennedy wrote, Phillips was entitled to a neutral decision-maker who would give full and fair consideration to his religious objection as he sought to assert it in all of the circumstances in which the case was presented, considered, and decided. I just followed that. Because he did not have such a proceeding, the court concluded the commissioner's order, which among other things required Phillips to sell same-sex couples wedding cakes or anything else that he would sell to opposite-sex couples, and mandated remedial training and compliance reports, that must be set aside, that ruling that would require him to do that. So how Orwellian is that? You won't sell your cake to same-sex couples, so we're going to give you remedial state-based training for diversity and make you fill out compliance reports. But the majority left open the possibility that a future case could come out differently, particularly if the decision-maker in the case considered religious objections neutrally and fairly. Other cases, the majority emphasized, must await further elaboration in the courts, all in the context of recognizing that these disputes must be resolved with tolerance, without undue disrespect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market. Surprise, surprise, Justice Ruth Bader Ginsburg dissented from the court's ruling in an opinion joined only by Justice Sotomayor, two of the most liberal justices. Ginsburg said there is much in the court's opinion with I agree, but she said strongly disagreed with the idea that the same-sex couple should lose this case. In particular, she argued neither the commissioner's statements about religion nor the commission's in particular, she argued neither the commissioner's statements about religion nor the commission's disparate treatment of other bakers who refused to make cakes disapproving of same-sex marriage justified a ruling in favor of Phillips. So there was a bunch of different opinions here. There was the majority opinion, but there were some concurring opinions by Alito and Gorsuch, pushing back against Ginsburg and Kagan opinions. So in the view of Justices Alito and Gorsuch, the different bakers' cakes refusing to make cakes for a same-sex marriage and refusing to make cakes disparaging same-sex marriage were from a legal perspective similar, and the commission was wrong to treat them differently just because it regarded Phillips' beliefs as offensive. Using strong language, Gorsuch emphasized that in the United States, the place of secular officials isn't to sit in judgment of religious beliefs, but only to protect their free exercise, yada, yada, yada. Because everything is just disappointing here. They had a chance to step up to the bat, and this was not about free exercise. This was about compelled speech. So here's the opinion. I'm going to include a link to the actual opinion of the court. You get some of the background, some of the procedural posture here. Here's the facts section that you get into, which I won't dwell on. You can, and I would suggest everyone read the opinions, because I don't want to be a gatekeeper. I want to give you the tools that you need to interpret this yourself. And anyone posting on the internet today could have just read the opinion. It's written in English, and so I'll include that link in the show notes page. Here's some history about Colorado civil rights. Make sure that you can see it. So they go through all that, and it's a rather short opinion. The main opinion is here. And this is where they kind of start with they end with the facts, and now they get into the actual decision on 2A right here. This is page 12 or 9 if you get into the opinion. So they laid a big goose egg. Now here is the brief of the petitioners. This is Masterpiece's final filing in the case. And let's see if we can find Jordan Lawrence's name right here. Man. Well, anyways, I thought his name would be on the brief. I swear to God, he did work on the case, Jordan Lawrence. Anyways, this is the table of contents here. And this is the argument section. Bam, right here. The commission has impermissibly compelled artistic expression. Hurley controls this case, so this is the reasoning. This is the second one. The court should follow its compelled speech decisions rather than respondents' new theory. I mean, so I'll include a link here. This is, like I said, the filing, if I'm not mistaken, of Masterpiece Cakeshop. I thought that Jordan Lawrence's name would be on here, but so go ahead and read this. And this is the correct decision here. This is about, so I'll read from the first page. Introduction. Expressive freedom is central to human dignity. This is a very libertarian brief, by the way. It requires that artists be free to make their own moral judgments about what to express through their works, and it forbids governments from commandeering the painter's brush, the sculptor's hand, or the soloist's voice to convey what is not in their minds or hearts. Respondents seek to carve out a new exception to that freedom. They insist that public accommodation laws override the freedom of for-profit speech creators who serve everyone but object to particular messages that clients ask them to express. No matter the form of speech, the message requested, or the protected classification at issue, respondents would empower governments to compel expression, even when the speech is custom art celebrating weddings, events inherently sacred for many, and the speaker is a graphic designer, filmmaker, photographer, fine art painter, or calligrapher. Respondents take the extreme position because they cannot deny that this case involves compelled speech. The Commission has applied the Colorado Anti-Discrimination Act not to the mere sale of Phillips's products, but to his creation of artistic expression. And its order requires that if Phillips continues to create wedding cakes at all, he must design cakes expressing support for same-sex marriage. This is Orwellian, and include on them any words or designs that appear on any of his other cakes. The First Amendment forbids such attempts to dictate the content of an artist's work. So you get more into this. Here's some of the law where they get into previous decisions that the Supreme Court has made. And so this is a proverbial feast. So I would get into this and read this, this opinion. I'll include that link in the show notes page as well. Here is the other side. So some on the left-hand side, they say, okay, this is a compelled speech case, but anti-discrimination laws do not compel commercial merchant speech. So they're really getting into like a philosophical question of, you know, when do you endorse speech? It's important that this Professor Tobias Wolff, I'll include a link to this as well, is points out that commercial speech is less protected under it receives less protection, it's still very protected, but it receives a lower level. And so he's basically kind of making the argument that, we're not compelling this cake maker to participate in this speech. No one will see it as his speech. I'll take the last paragraph because if it's good legal writing, this should sum it up perfectly. Some business owners are offended when told that the skills they sell to the general public may not be refused to gay customers, but the First Amendment is not a general license for people to avoid requirements they find objectionable. Public accommodation laws do not regulate the content of expression. They do not single out a favored message and require people to affirm or disseminate that viewpoint. And they do not hijack a street corner speaker and demand that he include unwanted content in his private expression. The speech clause poses no obstacle to prohibitions on discrimination in the public market. Well, I mean, that's just patently false. Trevor Phillips, or not Trevor, that's Grand Theft Auto. Is his name Trevor Phillips, the plaintiff? I'm getting sidetracked here, but he was being coerced into contribute to and physically write the message that he disagreed with. I don't know anything more Orwellian. Whether, the people at the wedding wouldn't recognize that he made the cake, I think is a moot point, is that he knows what the purpose of the cake is, and he doesn't want to agree with it. The one example that Jordan Lawrence used was, okay, well, what if this was something benign, like a cross? Man, I hope this example is clear enough, but they would say that there was some kind of here's just an interesting thought experiment is, what if this was a cross and Jordan Lawrence knew that he was selling the cross to the KKK and he knew that the cross was being burned and that he didn't want to participate in that, even though his and I think this gets into the actual writing on the cake, because it was like a rainbow frosting on the inside or something like that. He knew what it would be about, even if it was, so it would just be akin to, what if he was producing a cross and the KKK wanted to buy it to burn it in someone's yard? Interesting thought experiment. But I want to take a short little break. I'm at 22 minutes here. I don't want this to get above 30, but a short little break for our DonorSee plug. And this is something, DonorSee is a charitable application that you can get on your cell phone. And it is like Uber for charity. And it's really great. It gives you a personalized connection. There's very low overhead. So most of the money, like a huge chunk of the money, like 90% of the money that you give goes directly to charity. It's a very light operation. And you can see exactly where the money is going, because aid workers in the field will send you video reports and personalized photos, so you can see exactly what they bought with your money. And I've been sponsoring this one project. Jessie Schwartz is going to Uganda to help start a women's shelter. And she's going to be teaching English, doing some Bible studies. So if you don't like that, I'd suggest sponsoring a different project. But teaching English and helping these women start small businesses, building up their marketable skills. I think this is a worthy project, and so I put a link to these in my show notes page. If you do decide to give, please leave a comment in this activity area here, and I'll give you a shout out on the show. Just leave your name, or just say the Liberty Weekly podcast sent you here in this section, or send me an email at patrick.mcfarlane@libertyweekly.net. So yeah, but in closing here, and apologies for that, the KKK cross, I couldn't remember exactly the situation that he had brought that up, but this is clearly a compelled speech case. I just wanted to take kind of a moment to talk about the incorporation doctrine and the reason why the Supreme Court is setting social policy for the entire nation. So the reason why is that a lot of people don't know, and I did a poll on my Twitter the other day, polling this, and a lot of people weren't aware. I think it was 50-50, that the Bill of Rights was not intended to apply to the states at all. In the original drafting and ratification of the Constitution, the Bill of Rights did not apply to the states. The Bill of Rights only applied to the federal government. So we all know the story, at least I hope you do, is that the Constitution was giving certain enumerated rights to the federal government, and the federal government only has the rights that were specifically enumerated to it in the Constitution. And throughout the years, well, actually very close to when it was ratified, the Constitution was mortally flawed, as you see with Alexander Hamilton's National Bank, the Whiskey Rebellion, the Alien and Sedition Acts, and well, in fact, when the Alien and Sedition Acts were ratified in Congress, the Anti-Federalists, the people who were opposed to the Constitution's ratification, this group kind of grew after the ratification. Before ratification, the Anti-Federalists were a group that opposed ratification, and after it, people like James Madison, who were for ratification, kind of joined this group of Jeffersonian Democrat Republicans, as opposed to the Federalists. And the Federalists were very anti-France in the beginning, and they were pushing these Alien and Sedition Acts to cut down on the foreign influence. Sound familiar? To cut down on the foreign influence of the French Revolution, which they thought was kind of poisoning the Anti-Federalists or the Jeffersonians. And it came up in the arguments in Congress over whether to ratify the Alien and Sedition Acts. The Federalists were accusing, they said, you Jeffersonian Democrat Republicans, you don't think how can you say that the Alien and Sedition Acts violate the First Amendment, because you don't even think that the Bill of Rights should apply to the states? And this is very important coming up to the battle for federalism, that I'm going to talk about, states' rights, and why we would prefer the states over the federal government. And the Jeffersonian Democrat Republicans said, well, that doesn't matter. A lot of the states protect the First Amendment in their own bills of rights. So, we don't really, the federal government still can't violate that. It doesn't matter. So it just goes to show that it was very well understood that the Bill of Rights was not to apply to the states. And why that was the case is that we want a government that's closer to the people, so that we can have a lot of autonomy for small independent states, so that they can make a lot of decisions locally and on their own for their own personal reasons. So the Bill of Rights was never intended to apply to the states until the Civil War era amendments. And one of them, most famously, is the 14th Amendment. So the 13th abolished slavery. The 14th was the equal protection, the equal protection of the laws. So let's see. Let's just bring up the language of the 14th Amendment. See if I can okay, here we go. So I want to get the actual language here. So here's the language. The 14th Amendment addresses, let's see. Yeah, so no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So these are the equal protection clauses and the privileges and immunities clause. So it's very complicated, but part of the reason why the 14th Amendment was passed is because the federal government didn't want the southern states to limit the rights of the newly freed slaves, or at least that's the textbook reason that you'll get. And what this the 14th Amendment didn't automatically impose the Bill of Rights on the states. That the Supreme Court had to hold over a period, the next 150 years. They took one right at a time and applied them and lorded them, foisted them over the states. And I was really confused about this in law school, because I was listening to the Tom Woods show, and I had done a big project on nullification, which you can get, coincidentally, you can get that paper by signing up for my email list at libertyweekly.net in the horizontal bar. I think libertyweekly.net/email right here, the email list sign up. You'll get my report on the Kentucky and Virginia resolutions. But I was in criminal procedure class, and I had a civil libertarian as a professor, and he was just a veiled leftist. I mean, he came in crying the day after the Donald Trump was elected president because, yeah, he came in crying. So, so he was saying, you know, this is why the Bill of Rights is so important, and the 14th Amendment is so important, because we studied some hallmark cases where African Americans were denied counsel in the South. And yes, that was a horrible atrocity. Kangaroo courts all over the place. Horrible, I don't want to say systemic racism, but horrible institutional racism with these courts that I think is undeniable. Just denial of due process, torture, coerced confessions, you name it. And leftists will get you with that one. They'll be like, well, this is why we need the 14th Amendment. This is why we have to foist the Bill of Rights over the states, because without that, the states would be free to trample all over everyone's rights. And as a libertarian, obviously, you don't agree with that. And I don't agree with that. Although these people would have you believe that the federal government is some white knight protector of civil liberties. And that obviously is not the case. I mean, we have the kangaroo FISA courts, the administrative courts, all the NSA secret courts that they get into. You know, you have, just name all your atrocities that the federal government has committed. You know, Waco, the Trail of Tears, imprisoning Korematsu v. United States, and imprisoning the Japanese during World War II, which FDR, liberals. And so the federal government is no larger protector of individual liberties than any state government. And likewise, the state governments, they tend to be a little more friendly to liberty because they're smaller, but likewise, the state governments are not. But if you get the federal government has the most power, they are best with the Supreme Court. And this is what happened with the 14th Amendment being foisted over the states like this. Now the Supreme Court has basically ruled almost every single amendment in the Bill of the Rights, has imposed them on the states. And that means that you get the federal government setting this policy for the entire country. And so if the federal government or the Supreme Court makes the wrong decision, then the wrong decision is foisted over every single state. And at least in that sphere, the federal sphere, within their jurisdiction. So what you get now, and partly why we're so divided, the culture wars, is that that's our social policy, the 14th Amendment being foisted, has made every single aspect of our lives politicized. Every single one. You know, going to the bathroom, baking cakes, you know, this kind of stuff, this benign stuff that politics has no place in, the state has no place in. This is the result of an oligarchy imposing their will. And judicial review aside, I've done work on judicial review. Search my archives. I'll probably include some of the work that I've done in the show notes page here. So, yes. And so now you have this 9 unelected officials making these policy decisions for the entire nation. And if we got rid of the 14th Amendment, we would have the possibility of states making their own decisions, because, you know, people in New York are different than people in small town Minnesota, you know, or people in Florida are very different than people in the Pacific Northwest and Washington. Why should they have to live under the same policy? That just doesn't make sense. And I think the fact that we are leaving these decisions up to the 9 Supreme Court justices is very divisive. When you put the loaded gun of the government in the room, everyone reaches for that loaded gun, and they want to point it at everyone else. It's just, it's kind of sad, but in some sense, this could be the mechanism that leads to the fracturing of the United States, secession, and whether through outside influences. I think that repealing the 4th Amendment could help to prevent secession, because it would allow local autonomy, and that would be important too. So, yeah, this is it's disappointing. This ruling is disappointing, and I just wanted to get on the record just to try and make sure that libertarians know what they're talking about when they're talking about this ruling, because I've seen a lot of wrong takes on the internet today, and I feel like we're better than this. So this case did not turn on the this case didn't turn on what it should have. It turned on the free exercise clause. It should have turned on a compelled speech issue, and the Supreme Court should have stepped up to the plate here. I feel like they passed the buck. I feel like they know that what they're doing is so controversial, that they really just wanted to sidestep the issue here and not cause, they didn't want to rock the boat too much, I think. So in closing here, you know how to support the Liberty Weekly podcast. That's at patreon.com/Liberty Weekly. You go to patreon.com/Liberty Weekly. You can support me at different tier levels. That helps to go pay my internet hosting. It also goes to help pay my Libsyn hosting costs. I'm also investing in new equipment currently, so this would really help me out. You can get the access to extras, early access to show materials. You can also get access to my personal meme cache and the Murray Rothbard repository, which is an indexed and searchable repository of Murray Rothbard lectures, searchable by topic and time-stamped, put together by Daniel of the Actual Anarchy podcast. Great resource for us here. So head on over to my new home at the libertarianinstitute.org, and this podcast will appear in the podcast section right here. So if you go to the Libertarian Institute, this will appear in the podcast section. Here's my first entry. So also shout out to my buddies and compatriots in the Libertarian Union at libertarianunion.com. There's a whole bunch of new shows. Shout out to our newest member, Thijs van der Linde from the Netherlands, who provides a libertarian legal experience and theory from the European side. He is a law student in the Netherlands, so we're excited to welcome him. His show isn't available here on libertarianunion.com yet, but here are all my compatriots, so be sure to give them some love as well. And we've been doing these State of the Libertarian Union talk shows. We're trying to do one every weekend now, so I'll include a link to the show notes page if you're interested in that, but you get all of the hosts from our different podcasts coming together to talk liberty. And it's a really good time. It's a really good way for us to stay in contact. And there will also be an RSS feed for that show coming out very soon, so you can download that to your favorite podcatcher. So, yeah, I think that's all for me. I'll include these links in the show notes page, and I will see you back later on this week.